Mayday! Mayday! No, I'm not in trouble, it's just May, and so it's time to answer questions that $5 supporters asked in April. If you have questions for May, links are below. Just 2 questions this month, so let's start on Patreon where Darth Vega asks, what is the current status of post-quantum cryptography? People are saying that all current modern cryptography is going to be broken by quantum computers. Every data breach involving encrypted information, any sniff TLS traffic, it's all going to be exposed. I imagine the solution is to change all passwords once TLS and cloud password managers become post-quantum. But what about the average person who isn't aware of any of this? Are the IT people going to have to force a massive password reset? Also, is there any other advice you can give to the techies and non-techies to prepare for this eventuality? I think for the most part, the average person won't notice. If it's done right, they won't need to worry about it. The protocols will change in the background, but they already change every few years anyway. It's hard to think of the classic RSA algorithm falling to the wayside, but it is. With the new elliptic curve Diffie-Hellman, AES 256, elliptic curve 25519, Cha-Cha 20, and so on taking its place. So what did you have to do when CBC block ciphers and RSA key exchanges were deprecated? This transition should be as invisible to users as always. As for the current state, it's still very much a developing and evolving set of standards. NIST is finalizing its initial standards, with companies like Google and Cloudflare already implementing many of them, but no one thinks this is going to be the ultimate protection when quantum computers finally come online. The thing is, even these latest algos aren't where they need to be. They have to be able to protect against attacks by classical computers, not just quantum attacks. And that's a requirement. They already rejected Psych for being too vulnerable to classical attacks. But they still aren't quite as good against classical attacks as the current algorithms. I mean, the current algos are good! Really good! So once being deployed in browsers like Chrome and Firefox and over CDNs like Cloudflare is hybrid algorithms which give us the same protection from classical attacks because they use the same algorithms, but which also allow the protection from quantum computers. This lets us go ahead and migrate, which is important because as we speak, governments like Russia and China, not to mention our own NSA, are recording every last little thing we do. They can't break the encryption, but they salivate over the day where quantum computers let them go through it all like tissue paper. So the sooner we have post-quantum protection, the better. Not because quantum computers are coming real soon now, but because when they do come, the NSA and all the others can go back and look at all the conversations we're having today. There's nothing but time and lots of development standing in the way of making these post-quantum protocols just as secure from classical attacks as existing crypto. But we still have to get there step by step. It takes time to test and prove algorithms. But yes, the ultimate will be using the same algorithm to protect against both quantum and classical attacks. Again, though, when it all happens, the end user won't need to do anything special or even realize it happened. And over on Subscribestar, FunwithFacts asks, how do you think courts are supposed to figure out what rights are protected by the Ninth Amendment and how strongly they are protected? Well, maybe we should start out with the issue of why the Ninth Amendment is there in the first place. One of the big points of contention between the Federalists and Anti-Federalists is whether or not there should be a Bill of Rights. Many of the states found it unacceptable that a Bill of Rights was absent from the Constitution when it was finally presented to the people. In his second Anti-Federalist paper, Brutus wrote, those who have governed have been found in all ages ever active to enlarge their powers and abridge the public liberty. This has induced the people in all countries where any sense of freedom remained, to fix barriers against the encroachments of their rulers. The country from which we have derived our origin is an eminent example of this. Their Magna Carta and Bill of Rights have long been the boast, as well as the security, of that nation. I need say no more, I presume, to an American, than that this principle is a fundamental one in all the constitutions of our own states. There is not one of them but what is either founded on a Declaration or Bill of Rights, or has certain express reservation of rights interwoven into the body of them. From this it appears that at a time when the pulse of liberty beat high, and when an appeal was made to the people to form constitutions for the government of themselves, it was their universal sense that such declarations should make a part of their frames of government. It is therefore the more astonishing that this grand security to the rights of the people is not to be found in this Constitution. The response from the Federalists was that it wasn't necessary, since the Constitution is a document of limited powers. The federal government can only do what the Constitution gives them the power to do and no more, so a Bill of Rights is unnecessary. Alexander Hamilton wrote in Federalist number 84, "I go further and affirm that bills of rights, in the sense and in the extent in which they are contended for, are not only unnecessary in the proposed Constitution, but would even be dangerous. They would contain various exceptions to powers which are not granted, and on this very account would afford a colorable pretext to claim more than were granted. For why declare that things shall not be done which there is no power to do? Why, for instance, should it be said that the liberty of the press shall not be restrained when no power is given by which restrictions may be imposed? I will not contend that such a provision would confer a regulating power, but it is evident that it would furnish, to men disposed to usurp, a plausible pretense for claiming that power." You gotta admit, he had a point. Look at how much the statists have resorted to finding exceptions to an enumerated right, or in denying someone a right because the Constitution doesn't specifically mention it. But the cold, hard reality was exactly as Thomas Jefferson wrote to James Madison on 20 December 1787. To say, as Mr. Wilson does, that a Bill of Rights was not necessary because all is reserved in the case of general government which is not given, while in the particular ones all is given which is not reserved, might do for the audience to whom it is addressed, but it is surely a gratis dictum, opposed by strong inferences from the body of the instrument, as well as from the omission of the clause of our present Confederation which had declared that in express terms. It was a hard conclusion to say, because there has been no uniformity among the states as to the cases triable by jury, because some have been so incautious as to abandon this mode of trial. Therefore, the more prudent states shall be reduced to the same level of calamity. It would have been much more just and wise to have concluded the other way, that as most of the states had judiciously preserved this palladium, those who had wandered should be brought back to it, and to have established general right instead of general wrong. Let me add that a Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. With several states only accepting the Constitution conditionally based on the promise of a Bill of Rights, and two, Rhode Island and my home state of North Carolina, abjectly refusing to ratify the Constitution until a Bill of Rights was added, Madison knew he had to make sure the objection made by the Federalists was accounted for. His solution was the 9th and 10th Amendments. Of what would later become the 9th Amendment, Madison said in the House on 8 June 1789, "It has been objected also against a Bill of Rights that, by enumerating particular exceptions to the grant of power, it would not disparage those rights which were not placed in that enumeration, and it might follow by implication that those rights which were not singled out were intended to be assigned into the hands of the general government and were consequently insecure. This is one of the most plausible arguments I have ever heard urged against the admission of a Bill of Rights into this system. But I conceive that it may be guarded against. I have attempted it, as gentlemen may see by turning to the last clause of the 4th resolution." So now you have the question of, what rights does it cover? And here we have a bit of a contradiction. The whole point is that the full rights of the people cannot ever be enumerated for established reasons. So what sort of rights does the 9th cover? In the ratification debates, they talked about things like the right of parents to control the upbringing of their children, the right to travel, the right to have sex for reasons other than procreation, the right to read, the right to pursue a profession, at one time even jokingly referring to the right to wear a hat. You get the idea. The list of rights actually covered by the 9th is infinite, and it's a fool's errand to try and list them. So, what are the courts supposed to do with that? One method they use is to look at other legal documents of the time, such as the law as it existed at the time, or at the founding documents of the states and their declarations of rights. Another is to look at the history and traditions of the country and what was accepted throughout that time, even if it wasn't explicitly defended. And if you can ever make the case that such a right is covered by the 9th, you'd get the same protections as all the rest, and strict scrutiny would apply. But in all honesty, most of the time, courts deal with the 9th by avoiding it in any way they can, such as by using the Due Process Clause. Just as an example, let's look at Griswold v. Connecticut. Connecticut passed a law banning the use of contraceptives. Estelle Griswold of Planned Parenthood was arrested for giving birth control advice to married couples. She challenged the law as unconstitutional. The Supreme Court found a constitutional right to privacy in the 9th Amendment, having constructed it out of other express rights. William O. Douglas, writing for the majority, ruled, "The right of association contained in the penumbra of the First Amendment is one, as we have seen. The Third Amendment, in its prohibition against the quartering of soldiers in any house in time of peace without the consent of the owner, is another facet of that privacy. The Fourth Amendment explicitly confirms the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fifth Amendment, in its self-incrimination clause, enables the citizen to create a zone of privacy which government may not force him to surrender to his detriment. The Ninth Amendment provides, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. We deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system." Justice Arthur Goldberg wrote in his concurrence, "I do agree that the concept of liberty protects those personal rights that are fundamental and is not confined to the specific terms of the Bill of Rights. My conclusion that the concept of liberty is not so restricted and that it embraces the right of marital privacy, though that right is not mentioned explicitly in the Constitution, is supported both by numerous decisions of this court, referred to in the court's opinion, and in the language and history of the Ninth Amendment. The Ninth Amendment shows a belief that there are additional fundamental rights protected from governmental infringement which exist alongside those specifically mentioned in the first 8 constitutional amendments. To hold that a right so basic and fundamental and so deep-rooted in our society as the right of privacy in marriage may be infringed because that right is not guaranteed in so many words by the first 8 amendments to the Constitution is to ignore the Ninth Amendment and to give it no effect whatsoever." As for Potter Stewart's dissent, Goldberg wrote, "My brother Stewart dissents on the ground that he can find no general right of privacy in the Bill of Rights, in any other part of the Constitution, or in any case ever before decided by this court. He would require a more explicit guarantee than the one which the court derives from several constitutional amendments. This court, however, has never held that the Bill of Rights or the 14th Amendment protects only those rights that the Constitution specifically mentions by name." But the Supreme Court has never been able to land on a clear or binding standard for determining whether a right is protected under the Ninth Amendment specifically without reaching out to other parts of the Constitution. So there's really no clear answer to the first part of your question, but as to the second, once you can find that Ninth Amendment right under the penumbra of the rest of the Constitution, it is protected just as strongly as the enumerated rights, and strict scrutiny applies. So thank you so very much for watching. Comments for the comment god, shares for the share through, and please hit like, subscribe, and the bell, and check out other videos on my channel and like and share them as well. And of course, go to donate.bogosity.tv for all sorts of ways to support, including PayPal, Venmo, cryptocurrency, or become a regular supporter at Patreon, Subscribestar, or Discord to get these videos early and ad-free, and participate in live streams and AMAs like this one. Thanks again, and until next time, stay strong.